Well, we've heard from Gautam, who discussed some of the issues that when advising a copyright owner should be considered before issuing a letter of demand. David has followed up on that by talking about some of the things to consider before issuing proceedings. The focus of my presentation will be what happens next at the point once formal legal proceedings have been issued. The emphasis of my presentation will be on the perspective of the alleged infringer, but a lot of the things I'll be saying will have equal application to an applicant as well. For convenience, I'll refer to the alleged infringer from here on as a respondent. You might have got a feel now for the fact that copyright as a statutory regime is a fairly convoluted one. It's chock full of exceptions and differential treatment depending on the subject matter. It's no different, the situation, when you get to the next stage, which is carrying through the infringement to some sort of resolution. The first topic I'd like to cover is what's the first thing you do if you're acting for a respondent? Now, usually as advisors we'll meet a respondent because either they've gotten a letter of demand from a copyright owner or have had legal proceedings issued. In theory, there should be a letter of demand first, thanks to the overarching obligation and just general practice in IP. That's usually the first step, leaving aside an injunction or a moratorium or a search and seizure situation. But that being said, I'm sure you're all familiar with the client who ignores the letter of demand and only comes and sees you once the proceedings have actually been issued. But in any event, when you're acting for a respondent, the considerations are much the same. First thing to consider is identifying whether there's actually been an infringement. It's something of the flip side of what Gautam was talking about. By this stage, it should be fairly obvious what conduct it is that's being complained about. In almost all cases, it will be the act of reproduction of some sort of copyright work, but increasingly it may be communication to the public as things venture into the online domain, or adaptation. And this is another one of these wrinkles of the copyright regime. It's an infringement or to create an adaptation without the licence of the copyright owner of a literary, dramatic or musical work, but it is not an infringement to do an adaptation of an artistic work. That might seem strange, but it really relates to the definition of what's an adaptation. But nevertheless, be aware that there are a lot of wrinkles like that in the Copyright Act at all stages. So the first question is really, has there been any copying? Now that might seem like a fairly obvious question to ask, but it can sometimes be quite a challenging one to answer. As David mentioned, there needs to be a causal link between the copyright work and the infringing work. It may be that the resemblance between the respondent's work and the original work is in fact coincidental. That may be the case for particularly simple artistic or musical works. Architectural plans are a classic example. There's only a certain number of ways, given a particular space limitation, that rooms can be arranged around each other. The fact that one resembles another doesn't necessarily mean that there has been copying, and the applicant bears the onus of demonstrating that there is a causal link. That being said, there's at least one architectural company that's been very successful in protecting, through copyright, something that you might otherwise think is merely a concept. It's the sort of al fresco quadrant that's come up in a few cases now. But again, there still needs to be shown to be a link, a copying link between the two works. For other works like computer programs, literary works, it may be a bit more obvious if there's been copying, and it might be a bit harder to write off resemblance as coincidence. But that's it's nevertheless an inquiry you need to make when acting for a respondent. Also be aware that copying does not need to be direct. It is entirely possible for there to be indirect copying, and this might not necessarily need to even be pleaded or spelt out in the claim put against your client. This can lead to some surprising results in cases. So for example, if the original work consists of a sketch for a dress, and a dress has thereafter been made, and leaving aside the question of mass production, say it's a one-off dress, that the dress itself has been copied, and a respondent has made a similar looking dress, that act of copying the dress may nevertheless constitute a reproduction of the sketch from which the original dress was made, even if the respondent never saw that original sketch. So it is entirely possible for there to be indirect copying, and it can lead to some surprising results. A case that I did a couple of months ago, the liability judgment was handed down. I was acting for the respondent, and it involved the reproduction of a series of technical specifications in a statement of work for the production of a particular piece of equipment. And the claim was that that was an infringement of copyright in a similar listing of those technical specifications that had been given to my client 5 years earlier, when an earlier version of the same sort of equipment had been made. Now, that claim failed because we were able to trace back the causal link of how those technical specifications came to be in the statement of work. And it wasn't from the 2001 specifications, it was actually from a 2005 document that the applicant had given to a third-party contractor. And the applicant had failed to show any link between the 2001 copyright work and the 2005 copyright work, and that was enough to break the causal chain of copying, even though at first blush the list of specifications looked quite similar. So there can be some surprising results. It's important to get as much information from your client, the respondent, as possible. You do not want, in this area, unwelcome surprises to come out at trial. I remember a case a few years ago involving architectural drawings where the defence of the respondent was essentially one of independent creation. However, it came out under cross-examination of the drafts people that in fact they were lying and they had indeed copied the applicant's work, much to the horror of the respondent's legal team, especially because they thereafter lost the case. So you should encourage frankness wherever possible, especially because in a copyright context there are many opportunities to win the battle in other places. Which leads me to the topic of defences. Defences is probably an apt description. Let's say defences, exceptions and other circumstances where there's not an infringement. The copyright regime has been built up over time and it's somewhat reactive to changes in technology. And as a result, under the Copyright Act, there are a lot of defences to infringement, a lot of situations where a particular act does not constitute an infringement, or situations where, although it might be an infringement, the remedies available to an applicant are limited. I won't go into them in detail, but just be aware there's a whole raft of them and they arise in specific contexts. So without going into too much detail, the basic categories of defence that might be available to a respondent include the so-called fair dealing defences, where it's not an infringement to do certain acts with a copyright work for the purposes of research and study, criticism and review, parody and satire, and for the purposes of reporting news. There are also, more recently, a number of private use style exceptions that deal with television broadcasts in particular. You might have heard of them referred to as the format shifting and the time shifting exceptions, where if you want to record a television show for more convenient watching at a later date, that won't be an infringement of copyright. If you want to convert an MP3 file into, or if you want to convert a file and a CD into an MP3 file so you can put it on your iPod, again, that's a format shifting, and that won't be an infringement. Similarly, there are a number of other technologically based exceptions where to cover situations that otherwise arguably would be a reproduction. When you use the internet, there is a temporary version of what you're looking at downloaded into your computer or loaded up into the RAM, I think it is. David would be able to, is it the RAM where it goes?
Into a thing called the cache.
The cache, that's the word I was looking for, which otherwise might be a reproduction, but for certain exceptions in the Act that provide that they're not. Similarly, software, in reaction to the development of software and its treatment as a literary work under the Copyright Act, you are permitted with software to create backups of it, to get into it to see how it works, and to create interoperable software. So they may be exceptions that can avail a client. And finally, if you're acting for a carriage service provider, such as an ISP, you should be aware that there is a specific regime in the Copyright Act that provides for a very limited set of remedies against a carriage service provider, provided that they take certain steps that are set out in the Act. It focuses on the sort of behaviour and the activities that the carriage service provider provides, and it's quite a detailed regime, but be aware that there is one when acting for respondents who are engaged in those sorts of activities. So at this stage, the real question is, and it's the flip side of what David was mentioning, is it actually worth fighting the copyright claim that's been put against the respondent? There may be an opportunity to avoid going into proceedings at an early stage, and one of the key issues that you need to consider at this stage is what sort of remedies are available and what sort of level of relief is an applicant likely to get. That's the second point I'd like to address, which is how do we go about assessing the respondent's potential exposure in a copyright claim? Now, this is an expansion of some of the remedies that David mentioned. You'll be aware that a critical decision if you're acting for an applicant is, do you go for an account of profits or do you seek damages? You'll no doubt be aware an account of profits seeks to divest the wrongdoer of the profit obtained from the wrongdoing, whereas damages seeks to compensate for loss suffered by the copyright owner. They are not one and the same, and the principles for quantifying them are different, and at some point an applicant will need to elect between them. As David mentioned, if there is a potential for there to be a defence of innocent infringement, then only an account of profits is available. And innocent infringement essentially where the respondent was unaware or had no reasonable grounds to suspect that the relevant acts would infringe copyright, and that the onus is on the respondent to demonstrate that. Now, in terms of an account of profits, one of the benefits is it's somewhat more tangible and identifiable to say, I can identify what the profit made from the conduct was. The downside is that you will usually need to take additional steps as an applicant to get to that point. You'll need specific discovery or potentially some sort of evidence that lets you assess this, and then you'll need to analyse it. But nevertheless, using normal accounting principles and established authorities, you can work out what profit was made from infringing conduct. It also can be quite costly, though, to pursue this course of action, and it's not necessarily predictable in its outcome. That's because with an account of profits in a copyright context, the courts will look at the proportionate benefit. How much of the profit is attributable to the use of the copyright work as opposed to the overall conduct? And that might be a problem for an applicant where the offending copyright work is only a small part of the overall profitable activity engaged in by the respondent. In contrast, general damages has the benefit that it's a wider inquiry. It seeks to compensate loss. So traditionally, courts tend to look at the loss of sales that may have arisen in the hands of the copyright owner. In some circumstances, they apply a licence fee approach. They ask hypothetically, what licence fee could the copyright owner have received in exchange for the respondent's use of the particular copyright work? And one that shouldn't be ignored is you can recover reputational loss, harm to a reputation as a copyright owner. That might be especially useful where the respondent has been engaged in the sale of, say, counterfeit goods that nevertheless incorporate a copyright work of yours. The other key benefit from seeking damages is you can obtain additional damages awards under the Copyright Act. I'll talk about those in a moment. The downside is that proving damages, again, can be difficult. There needs to be a causal link between the infringement and the copyright owner incurring the particular loss and damage. That also makes it difficult to quantify and predict what a court might award. Sorry, is there a question there? Oh, sorry. Difficult to predict what a court might award by way of general damages, except in the clearest of cases. Again, the focus is what was actually done with the work and what harm arises from the use of the work as opposed to the conduct in general. As I said, the prospect for additional damages shouldn't be ignored. Additional damages tend to be either a sting in the tail for a respondent or a slap in the face for the copyright owner. It's a bit of a wild card. It's a discretionary remedy. The applicant first needs to show that it's suffered some form of general damages before additional damages become available. It is a means by which the court can express disapproval for the conduct engaged in by the respondent. So the court will consider things like how flagrant was the infringement, did the respondent seek to cover its tracks, how persistent was the respondent in engaging in the conduct even after being notified of the claim, did the respondent admit wrongdoing or at least the conduct involved. This is something on which you'll need to get quite detailed instructions from the respondent and also apply your own judgment as to whether there's a risk of additional damages. Also be aware that additional damages are not necessarily proportional to the general damages. There are plenty of cases where additional damages awards have been greater than the actual compensatory damage award. The high watermark for additional damages tends to be in excess of $100,000, $150,000. That tends to be reserved for the most serious cases such as software pirates and where there's been large-scale commercial exploitation of an infringing work or very deliberate conduct. That's sort of the high watermark. In the ordinary case, I would be surprised to see additional damages getting much higher than $30,000. But that being said, everything depends on the facts. An applicant should be aware, though, additional damages are not a ticket to retirement by any means. They shouldn't expect to see millions of dollars despite the somewhat exemplary or punitive nature of them. Now, this sort of inquiry is relevant for both sides. It helps determine whether it's worth settling this case early or indeed whether it's worth defending it or bringing the case in the first place. And that brings me to the third topic I'll discover in the last, I'll canvass in the last of the topics I propose to cover, which is certain strategic matters that might be considered by a respondent, especially in a copyright infringement proceeding. The first thing that I like to discuss with a client is there a prospect for giving open undertakings very early? Now, it's not always every situation where giving undertaking not to engage in certain conduct will be appropriate for your client, but if there's no real need to continue using the infringing work, if it's very early days in the use of the infringing work such that very little by way of profits or damages can be expected to have arisen, and if the copyright work can be readily modified to remove the component that's said to be infringing, it may well be useful to offer or even give undertakings not to continue to engage in certain conduct with respect to the infringing work. And this takes a lot of steam out of an applicant's case, especially if there's an injunctive relief component that there's being sought. Can even be coupled with an offer to pay the legal costs to date. If it's only a letter of demand, that might be quite minimal and should be easily predictable. And I found it's a very powerful tool at a first directions hearing to have in your hands these open undertakings and be able to say to the court, we're not really sure why we're here, it's a very minor infringement, it's going to be well in excess of it's going to cost more to run this case than any conceivable damages award. And the court quite often gets on your side in that sort of context. It also puts a lot of pressure on the applicant to consider whether it's really worth proceeding. If you take away the injunctive relief, sometimes there's not much left. The next decision you should really make as a respondent is to pick your battles. It is very rarely in a copyright infringement case a good idea to challenge every single element of the infringement claim. So you should ask yourself, are we going to challenge, for example, subsistence, the fact that copyright exists at all? Really what you'd be challenging there is the concept that is the original work actually original? That's one of the key criteria, as Gautam mentioned. Are you going to challenge ownership, or at least get the applicant to prove that they own the copyright work? It's not always worth doing, but as Gautam mentioned, it's one of these issues that can come back to bite an applicant during infringement proceedings. It's never a good look in infringement proceedings for an applicant to have to amend its pleadings and rely on an assignment of copyright that happens after the proceedings have been issued, there's a real question about whether the proceedings should have been commenced at all. There may be cost consequences at this stage, and practical consequences, as Gautam mentioned. It may limit the damages that are available to the applicant. Because leaving aside equitable assignments and other situations, if just in a vanilla copyright assignment, including one that includes the right to sue for past infringements, all that the applicant can enforce is the author's loss and damage, which might be minimal. And there was a case involving, Your Honour, the Sea Folly case, where the copyright claim, that component, that was the case. It involved an infringement of photographs. The assignment of copyright did not take place until after the conduct had already occurred, and as a result, there was no proof of the harm that had been suffered by the photographer, in particular, by reason of the infringement, as opposed to the party engaging the photographer, and as a result, there would have been no copyright damages available. Has there been a reproduction? As David mentioned, that might be a vexed question that requires expert evidence. Has there been a substantial part taken? Again, in some cases, that may be a very significant issue. What is substantial in the context of a very large piece of software? What is substantial in respect of a piece of music or an architectural plan? And then also consider, is it worth splitting liability from quantum, or dealing with some of the other issues in a separate trial with the idea that it will avoid the need for a subsequent trial if findings go in your favour? That might be particularly useful if there are multiple copyright works in suit, or the conduct is consisted of different acts over time. Considering all these issues and really focusing the battle tends to result in a much cheaper case to run, a more confined discovery obligation, possibly avoids the need for expert evidence, and in some cases avoids the need for a trial on quantum altogether. That being said, not always. I have a case coming up next month where it's the liability hearing. The applicant has failed on every single claim except for one very minor copyright claim, where we admitted the reproduction. Now, in ordinary circumstances, it's one of those reproductions, one of those infringements that all of us will do almost on a daily basis, but that hasn't stopped the applicant from seeming to think that it's suffered hundreds of thousands of dollars of loss from essentially a reproduction of an obsolete piece of an obsolete diagram. So those are the 3 points I wanted to cover. Tying it all together, in summary, I think it really boils down to these sort of 3 points. First, as a copyright owner, it's worth getting all of your ducks in a row very early on to avoid problems down the track. Secondly, as a respondent to a copyright claim, you need to consider what you're going to fight and how. And then thirdly, when you're advising either side, you need to be realistic about the amount of money that's really at stake, and if you're the applicant, how you're going to prove it. Now, none of those propositions is particularly startling, but what is different about copyright is the particularly convoluted way that the statutory regime works. And I'd say, as a result, there's a relatively greater level of uncertainty in copyright claims than there might be in other sorts of intellectual property where you're dealing with a registered right. And that concludes the issues I wanted to cover with you guys.
Thanks very much, Alan. The time has now come where we can field any questions that anyone may have of any of the presenters.
A question about groundless threats. If you are subject, you've got a groundless threat from the opposing side, what kind of categories of damages can you then claim an action against groundless threats? Is it just purely like legal costs to take an action, or?
Well, you can injunct them from bringing the claim or continuing to make the threats, and you can get your costs associated with having to deal with it, so legal costs and things like that. Doesn't come up all that often, and often you'll find that one of the things you do when you bring in groundless threats or raise the prospect of a groundless threats application is you encourage the other side to actually issue proceedings, at which point it's not a groundless threat of legal proceeding. The proceeding is now on foot. But it can force the issue, yes.
If I could just add one thing to that. So if in some way that information about your purported copyright infringement has gotten out to the market in some way, there might be damages arising from that. So if the letter of demand is somehow being disseminated, that might justify seeking damages to reputation.
Yeah, I guess because the reason I ask is sometimes when writing those information, if it is, a grey area, how much you do threaten that kind of thing, whether it is a concern, the consequences of doing it, and whether it's a real concern as far as that seems to be difficult to quantify.
That makes it all the more important if you're acting for an applicant to deal with things Gautam was mentioning, and making sure that you actually have ownership of the copyright work before you start going around telling people that they've infringed. You need to make sure that it doesn't have to be necessarily certain that there's been an infringement, but at least a strongly arguable case that there's been some sort of unauthorised reproduction that's gone on.
Does the mere assertion that in fact someone is infringing your copyright and the public assertion of that amount to a groundless threat, or do you need to be threatening to enforce your rights?
Yeah, there's been some cases on that. I think I can't remember exactly the disposition, but I think you need to threaten legal proceedings. You can't just say, "Be aware that we have copyright ownership of these things." You're on notice.
And that X is breaching it by their conduct.
Yes, but if I think the cases say if there's an implied threat to thereafter go the next step, that could be a groundless threat. I'm not 100% sure.
Can I just add, depending on how it is made, I'm not aware of case law in Australia on this, but overseas there have been matters where instead of it being seen as a groundless threat, it's been seen as an imputation that gives a rise to a possible defamation action. So I think all correspondence like that needs to be considered in terms of if it's communicated to someone else, what would the consequence be?
But for it to be defamatory, it also needs to be published outside of the recipient. So if you're acting, you often get clients that come to you and they're upset that something that their competitor has done, and they want not only to issue a letter of demand, but be able to tell the market, we have now taken this extra step. That's not usually a good idea until you're very sure about what you're saying.
Sorry, Alan, there's a case that Justice Jessup in Englehard where he talks about there was a particular cross-claim about the groundless threat when issued a proceeding that Justice Jessup dismissed the groundless threat on the basis that the proceeding had many issues, so it can't be groundless anymore. So there's an interesting discussion about some of those things. Alan, I was going to ask, just in terms of procedural question, I guess, for the panel, including Your Honour, is there still much interest in the federal court in the fast track list, and do people still feel that, in a copyright case where perhaps there's, as you're talking, Alan, that, perhaps there's just a distinct issue as to whether, there's no issue of subsistence, it's really just a reproduction question, whether that's the best avenue to go to sort of keep the case narrow on the issues and to move it through the court process as fast as possible. Are you guys still having a lot of experience in that list, or are you finding that you just...
I still like the fast track list, even for copyright claims, especially if there's potential for it to blow out to be a more complicated claim. That being said, I really am a big fan of the Federal Circuit Court for copyright matters as well. There's some very good judges down there who are very good at dealing with them quickly. Yeah. You've just got that cost consequence to worry about as well. In my experience, you can in the Federal Circuit Court apply for your costs to be taxed on the Federal Court scale, but in copyright cases I've done and where the other side has sought that, they've been unsuccessful. So it's a fairly rare case. So once you go in the Federal Circuit Court, you're confined by and large to the scale of costs that are recoverable under the Federal Circuit Court rules. I don't know if anyone else has a different view.
From the court's point of view, can I say this, that we've had some difficulties in the last couple of years in running the fast track system because we simply haven't had enough judges. We were down to 9 in Melbourne, and to keep to the promised timetable became difficult and then eventually impossible. But we're getting back to it now. We've had, as you probably know, 3 new appointments in the last few months, and once their effectiveness starts to bite in the system, then I think we'll be able to operate the fast track system again as it was intended, and you'll get quick results. Any other questions? Well, perhaps just... yeah, sorry, Jonathan, yes.
Just in relation to Alan's point, that was a really good one. One thing that we've found, just to everyone, in relation to copyright cases, especially subsistence, where you do have respondents that do try put up a hurdle at every point, and especially when you're running cases where you have works that have been created overseas, and the difficulties of having to bring witnesses out. Notices to admit can be very effective. Obviously, the cost consequences that flow from those, and even in cases, back to the Engelhard case, where we were an unsuccessful applicant on the reproduction question, we were successful getting our costs of the subsistence on the basis that the respondent should have admitted that he's on it. Justice found that should have been admitted, and therefore at least got our cost of that component. So it is important to, as an applicant, I think, to keep pressure on the respondent, especially once you've discovered your documents. It's pretty obvious that there is copyright subsistence and an author or less. It's just a good strategic thing to have to think of if you are an applicant.
It's something of a big call for a respondent to try to challenge something like subsistence or ownership. It's not really going to be something that's within the respondent's knowledge necessarily. There might be some cases where the original copyright work is itself derivative, or the two parties will be operating in the same industry, so the respondent is able to say, well, no, that they never invented that, that's not their work, or it's derived from this, it's not original. But I agree with that.
Well, we've come to 9 o'clock when we need to be heading in our different directions, but could I thank each member of the panel for bringing a very practical perspective to bear on the conduct of litigation in the IP area, and I hope that you all go away better informed. I certainly will. Thank you.